Welcome to Black Joy Interrupted, where we document patterns of power, decisions, and outcomes, so we can see clearly what others pretend not to see. In today's video, we're looking at two things. First, the Supreme Court's recent 5-4 decision where Justice Clarence Thomas authored the majority opinion preserving federal immunity in a case involving intentional mail non-delivery. And second, we're looking beyond the opinion itself. We're examining the pattern, the record, and the type of alignment that keeps appearing in Clarence Thomas's jurisprudence, and how that alignment shapes the Black community in real, measurable ways. This isn't personality commentary. This is a structural analysis. Because if you want to understand how progress gets narrowed without headlines, you have to look at who holds the pen. So, let's begin. Clarence Thomas is a human being. Of course he is. But that's not the debate. The debate is what kind of human he chose to become, inside a country that has always needed Black people to play a role. Because America has two favorite types of Black men, the ones it can punish and the ones it can use. Clarence Thomas isn't simply conservative, he isn't simply controversial, and he isn't simply misunderstood. He's useful. Useful to a political project that has spent decades trying to shrink civil rights enforcement, weaken voting protections, and lock Black communities out of power while smiling in our faces and calling it neutral. And the reason this matters is because Clarence Thomas did not build his life in a vacuum. He benefited from the very legal and social progress Black people fought and bled for. He climbed inside a system shaped by civil rights wins, and once he got a lifetime seat, he helped pull the ladder up behind him. That's not strength, nor is it independence, and it damn sure isn't courage. It's sabotage with a robe on. And what makes it worse is that the damage isn't theoretical. It shows up in who gets protected and who gets exposed. It shows up in whose vote counts and whose vote gets diluted. And it shows up in whether Black people can challenge discrimination in court or whether we get told to prove the obvious while the clock runs out. So today, we're not doing personality analysis. We're doing patterns, receipts, networks, decisions, and outcomes. Because if you want to understand how Black America keeps getting set back in plain sight, you need to understand the type of man Clarence Thomas chose to be. Not by the color of his skin, but by the content of his record. Let's talk about the mail. The United States Postal Service. Because while everybody thinks the system only breaks your back with sirens and headlines, it also breaks your back with paperwork, with procedures, with you can't sue. And if you think that sounds small, you're about to see how big it is. This is the United States Postal Service versus Conan. It was argued on October 8, 2025, and decided on February 24, 2026. And it's not a story about missing envelopes. Nope. It's a story about what happens when the government touches your life every day, then tells you have no remedy when it decides to play in your face. Here's what Conan says happened. LaBen Conan owns 2 rental houses in Euless, Texas. One's on Saratoga Drive and the other's on Trenton Lane. She rents rooms to tenants and sometimes she stays there herself. And in that neighborhood, the mail doesn't go door to door the normal way. It goes to a central mail structure with a box for each house. Owners get keys. So, owners pick up the mail. Conan had the keys for both properties. So far, nothing's unusual. Then, May 2020 hits, and she notices something that seems small until it isn't. There's been no mail for days. When she looks into it, she discovers something wild. The assigned carrier allegedly changed the listed owner from Conan's name to one of her tenants' names. Then that same carrier authorized a lock change so the tenant could have his own key to the mailbox. And of course, this was done without her consent. So Conan goes to the local post office as a normal person would do. And she's told the following.
Mail delivery to Saratoga is being stopped until an investigation can determine the proper owner.
So, she gets no mail for months. Not even a late delivery. Not even a, it's been delayed. She's received no mail. At all. Then it gets worse. She later learns that mail addressed to her and her tenants was being returned as undeliverable. Not just regular mail, but important mail as well. The kind of mail that affects your life, your money, and your stability. And because she's a landlord, the consequences don't just stay on paper. She says the disruption caused tenants to leave, and it made it harder to attract new tenants. So she starts using private carriers. Because at a certain point, you're not being inconvenienced, you're being targeted. Then in 2021, she says postal workers allegedly stopped delivering mail to the Trenton property too, after discovering she owned that one as well. Now it's both of her properties. Now it's a system. This is where she does what a lot of people don't realize they can do. She signs up for informed delivery. That's the service that lets you see scans of incoming mail. So she can literally see mail that's supposed to arrive, and then watch it not arrive. That matters because now it's not.
Maybe you missed it.
It's
I see it, and you're not delivering it.
So she requested the mail be held at the post office so she can pick it up in person. And she says employees still won't give it to her because she doesn't have identification for every addressee. And after all of that, she files a few administrative complaints. And she gets nowhere. So she does the next thing the system hates. She sues. In January of 2022, Conan sued the United States under the Federal Tort Claims Act for not just, "they hurt my feelings." She hits them with state law tort claims. Claims like nuisance, tortious interference with prospective business relations, conversion, and intentional infliction of emotional distress. She says she lost rental income. She says she was deprived of her mail. And she says she was put through distress by postal workers. And let me pause right here, because this is the part where people think the law is about justice. But the law is also about gates. For example, who gets into the courtroom and who gets turned away at the door. The district court dismisses her case, not because it says she's lying, not because it says nothing happened, but because of sovereign immunity. That's the legal concept that says the United States can't be sued unless it allows itself to be sued. And the Federal Tort Claims Act is the law that allows certain lawsuits, but inside that law is a carve-out, a trap door, if you will. It's called the postal exception. And it says the government keeps immunity for claims arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. So the district court says, if your harm arises from non-delivery of mail, the government is immune. And the court says this exception isn't limited to negligence, meaning even if it was intentional, it's still immune. So, Conan appeals, and the Fifth Circuit reverses the lower court. The Fifth Circuit says the words loss, miscarriage, and negligent transmission do not cover intentional refusal to deliver mail. Basically, they read it like this.
Negligent transmission is negligence. Loss is mail destroyed or misplaced unintentionally. Miscarriage is mail delivered wrong, but not intentional withholding.
And here's the key. Other circuits disagreed. The First and Second Circuits said the postal exception applies even when the harm comes from intentional misconduct. So now we've got a split in decisions. And when circuits split, the Supreme Court shows up to the scene like a landlord who just got called about a leaking roof. The next thing we know, the Supreme Court tags itself in by granting a certiorari to resolve the split court decisions. It's now October 8th, 2025. All 9 justices are in the building. No shadow docket, no shortcuts. This case gets argued. The lawyer for the United States steps up first.
Argument next in case 24-351, United States Postal Service versus Conan. Mr. Liu?
Mr. Chief Justice, and may it please the Court. The postal exception to the Federal Tort Claims Act preserves the United States immunity for any claim arising out of the loss, miscarriage, or negligent transmission of mail.
And the government's position? The government can't be sued. That's it. Didn't get your mail? Immune. Was it negligent? Doesn't matter. Was it intentional? Still doesn't matter. The statute says loss, miscarriage, or negligent transmission. And the government leans on those words like a shield. They say loss doesn't mean accident. They say miscarriage just means failed delivery. They say Congress stacked 3 overlapping terms on purpose. Translation, we don't care why it didn't get there. All that matters is that it didn't get there. And if that's the harm, case closed. Justice Sotomayor, she doesn't let the case breathe. She starts pushing. Hard. What if a postal worker intentionally withholds ballots? What if they stamp deceased on someone's mail out of spite? What if they target someone on purpose? Is that immune too? The government doesn't blink. Yes, if the harm flows from non-delivery, it's covered. Now the air changes. Because this isn't about a lost birthday card anymore. It's about whether deliberate misconduct gets wrapped in a federal shield. Justice Jackson. She goes surgical on the government. She doesn't argue emotion. She argues structure. She asks, what's this case really about? Is it about missing mail? Or is it about using the mail system as a weapon? She lists the claims: intentional infliction of emotional distress, tortious interference, and nuisance. Those aren't oops claims. Those are you did this on purpose claims. She's testing the line. But the government keeps widening it. If mail non-delivery is part of the story, then immunity applies, no matter what else you call it. Justice K. Gann. She focuses on the words loss, miscarriage, and negligent transmission. She slows it down. Why does negligent modify only transmission? If Congress meant to protect intentional wrongdoing too, why not say that? Why list 3 words with 3 different meanings if one word would do? Because when lawmakers group words together, they usually don't share character. And those 3 words, they don't sound like mistakes. Justice Gorsuch. He attacks from another angle: redundancy. If loss covers everything, why mention miscarriage? Why mention negligent transmission? Why not just say, any claim arising out of mail delivery? If the government's reading is right, 2/3 of this statute is dead weight. That's not how drafting works. Justice Alito. He isn't focused on grammar. He's focused on consequences. He asks, if you carve out intentional misconduct, what stops every plaintiff from just saying it was intentional? What stops the flood? His concern isn't motive. He's concerned about volume, exposure, and opening the door too wide for others to sue. Justice Kavanaugh. He brings up stare decisis. The Dolan case, he's thinking precedent. He's thinking of stability. He's not giving away his vote, but he's signaling caution. And the court has touched this statute before. He's weighing how far the government is able to go. Conan's lawyer. She takes the stand and reframes the case for the court, bringing it back to their position. This isn't about misplaced mail. This is about alleged targeting. The statute says loss, miscarriage, or negligent transmission. If Congress wanted blanket immunity for all misconduct involving mail, it could have said that, but it didn't. Negligent transmission signals something. Negligent, that word matters. And she pushes the gravamen idea. When the heart of the lawsuit is harassment, not an accident, the exception shouldn't swallow it. The courtroom. If you read or listen to the transcript carefully, you would be able to feel the divide. The conservative justices circle around textual breadth, administrative burden, and floodgates. Then the liberal justices circle around intent, structure, and accountability. You don't need a vote count yet. The lines are already there. February 24th, 2026. The court's opinion. Its decision drops. Justice Clarence Thomas writes it. Roberts joins. Alito joins. Kavanaugh joins. And Barrett joins. It's a 5-4 decision. Thomas adopts the government's reading. He says miscarriage means failure to reach its destination. Failure can be negligent, and failure can be intentional. He says loss means deprivation, and deprivation includes intentional withholding. And that's it. The shield stays up, even for intentional non-delivery. If your harm arises out of mail not getting where it was supposed to go, you can't sue. So Thomas frames it like this. Congress didn't create an exception for only negligent problems with mail. Congress created an exception designed to keep mail delivery complaints out of court because it would be too burdensome, too frequent, too expensive, and too tied to the value of the mail's contents. So, from the court's perspective, this isn't about a motive story. This is about closing the courthouse door. Justice Sotomayor dissents. and she's joined by Kagan, Gorsuch, and Jackson. And the dissent says the quiet part out loud: the postal exception is narrower than other exceptions. Congress could have immunized all postal activity, but it didn't. It listed specific categories, and the dissent reads those categories as negligence-style problems, not malicious misconduct. And here's the detail that matters for U.S. citizens. Conan alleges intentional withholding for racial reasons. She alleges employees didn't like that she was a black property owner and leasing rooms to white tenants. So Sotomayor is warning that the court's reading transforms the postal exception into blanket immunity for bad actors inside the system. And she's saying that's not what Congress wrote. What does this mean in plain English? Well, it means this. If the people handling your mail decide to delay, obstruct, or refuse delivery and your harm arises from that non-delivery, the Supreme Court just expanded the shield that protects the government from being sued. And if you're the type of person who thinks that won't happen to me, well, that's probably what Conan thought too. Now, zoom out. This case wasn't just about one landlord. It was about infrastructure. And in modern America, mail is infrastructure. Mail carries ballots. Mail carries voter registrations. Mail carries cure notices. And mail carries the ability to participate at all. So when the court removes damages as a remedy for intentional non-delivery and says that the Postal Service is immune, what happens next? This is another tool for making sure that democracy is a thing of the past, and abruptly. Essentially, the U.S. Supreme Court just handed the government a weapon via the United States Postal Service, a weapon to erase ballots, a weapon to silence voters, and a weapon to target whomever they want to target next. Today, it's black homeowners. Tomorrow, it's women. Then it's LGBTQ voters. And once they start, there will be nothing to stop them. They can lose ballots. They can forget registrations. And they can wipe entire communities off the map and hide behind immunity. And no one will be able to sue. This is another piece to their blueprint. It's voter suppression legalized. And if you don't see it now, well, maybe you'll see it when your vote disappears. So again, this case isn't just about mail. It's about what happens when the machinery of participation becomes harder to hold accountable. That's the context. That's the shift. And that's why this decision matters far beyond one plaintiff. It was a 5-4 decision. That's it. That's the difference between accountability and immunity. Now here's where people try to get cute. They'll say,
Well, that's just the court.
No, courts don't exist in a vacuum amongst themselves. Opinions don't fall from the sky. Someone picks up the pen and carves out decisions that impact an entire nation, and sometimes the entire world. And in this case, it was Clarence Thomas. Think about that. The same Clarence Thomas who knows what discrimination looks like. The same Clarence Thomas who grew up in segregated Georgia. And the same Clarence Thomas who benefited from civil rights protections he now refuses to extend. So the real question isn't, what did the court do? The real question is, why does the man who lived under the boot now tighten the straps? Because here's the uncomfortable truth. Blackness isn't a costume. It comes with responsibility. Representation should equal protection. But unfortunately, being black doesn't automatically mean serving black people. Just like proximity to power doesn't always produce liberation. And unfortunately, sometimes, it produces obedience. And if you don't understand that, you don't understand Clarence Thomas. Now let's talk about who he really is. For decades, Clarence Thomas has voted to narrow the very laws that expanded black political power, voting protections, affirmative action, and civil rights enforcement. He's done this quietly and consistently. And when the question before him is whether or not federal law should step in to protect communities from discrimination, he almost always moves in one direction, toward insulation, toward immunity, and toward narrowing the path to sue. That's not random, that's a pattern. And patterns matter more than personalities, because when you see a pattern, you stop asking, why this case? And you start asking, why this man? And that question deserves its own room. Because Clarence Thomas isn't complicated. He's aligned with a legal philosophy that treats race-conscious remedies as the problem. aligned with a movement that believes federal civil rights protections go too far, and aligned with a structure that rewards judges who narrow access rather than expand it. If you want to understand how he got there and why he keeps landing on the politically right side of history, we're going to have to pull that thread all the way. That's part 2, and that's where we'll leave it. If you made it all the way to the end, we appreciate you. This case matters more than most people realize, and in part 2, we're going to pull that thread all the way into Clarence Thomas's record, his alignment, and how he became so useful to the structure we just discussed. If you found value in this breakdown, like this video, subscribe to our channel and share it. It helps this conversation reach people who aren't hearing it anywhere else. This is Black Joy Interrupted, where we expose the patterns and systems that quietly destabilize our communities long before the headlines catch up. We'll see you in part 2.